like justice itself, lies in the eye of the beholder. But there are many different kinds of court packing. Here's one. When Justice Scalia died in February of 2016, when Barack Obama was president, Senator Mitch McConnell announced 10 and a half months before the presidential election that the Senate would not be considering any replacement. The Judiciary Committee would not have any hearing, there'd be no vote in committee, and there'd be no vote on the floor. When people asked why, that makes no sense to hold the Supreme Court seat open, to hold that vacancy open for nearly a year, he said it was too close to the next presidential election and the people should decide. Of course, the people had decided in electing Barack Obama to one of those genuine, bona fide 4-year terms in office, like every other president. Well, we've got a controlled experiment about what would happen, because that was held open. Merrick Garland was nominated by Barack Obama and was left twisting in the wind for nearly 11 months after the death of Justice Scalia. Then, Trump, when he got in, was able to nominate Neil Gorsuch to the seat in his first week in office, and that seat was open for 422 days. And Mitch McConnell bragged about it, calling it the most consequential decision of his entire public career. And of course, it cemented the rapid movement of the Supreme Court to the right, to incarnate the MAGA agenda on the Supreme Court. Well, look, here's what happened when Ruth Bader Ginsburg died. Now, she died on September 18th, 2020. So close to the next election, which was less than 2 months away, that early voting had started in a lot of the states. So it wasn't even 2 months away. And then the Democrats asked Mitch McConnell, some reporters asked Mitch McConnell, well, of course, you're not going to have hearings or a vote or anything in the next few weeks, are you? And he laughed it off. He laughed off the suggestion that they would maintain the same rule that they had used to block Merrick Garland and President Obama from having a seat. And then they rammed through the nomination of Amy Coney Barrett within 2 months, consolidating the right-wing anti-choice, anti-environmental regulation, anti-labor, anti-voting rights, anti-democracy majority on the Supreme Court. Had the original McConnell rule been applied, or even a reasonable approach taken with just a few weeks before the election, that Supreme Court seat would have been filled by President Biden, not by Donald Trump. Biden won that election, by the way, by more than 7 million votes. If you're interested in what the people want, 306 to 232 in the Electoral College. I know some people came down to overthrow the election.
A single court ruling, 6-3, and overnight 1/3 of black representatives in the U.S. Congress faced the risk of losing their seats. On Wednesday, April 29, 2026, the Supreme Court announced its decision in the case of Louisiana versus Callais. The decision effectively rendered Section 2, which has been considered a cornerstone of the Voting Rights Act since 1965, inoperative. Justice Kagan wrote in her dissent, "Today's decision almost makes Section 2 a dead letter." Within 2 weeks of the decision being announced, Republican-controlled states like Louisiana, South Carolina, and Tennessee began the process of redrawing black-majority congressional districts. And this process was not a secret conspiracy. On the contrary, it was an open political struggle conducted in front of the public, with press conferences, state assembly sessions, and protests. The chair of the Congressional Black Caucus, Yvette Clarke, summarized the situation at a press conference on Capitol Hill. 19 of the 62-member caucus are facing the risk of losing their seats. If you want to see such truths with this clarity, subscribe now and turn on notifications. Let's return to the stage. The Supreme Court's decision, the collapse of Section 2. To understand this crisis, one needs to know exactly what the Supreme Court ruled. On April 29, 2026, the Supreme Court, in a 6-3 decision written by Justice Samuel Alito, ruled that Louisiana's creation of a second minority-majority district was an unconstitutional racial gerrymander and upheld the lower court's decision. The court ruled that Louisiana's creation of a second minority-majority district to comply with Section 2 of the Voting Rights Act constituted an unconstitutional racial gerrymander. The court determined that Section 2, as interpreted in Callais, does not require the creation of this second minority-majority district, and therefore there is no compelling state interest justifying the use of race by the state in drawing the district. If we analyze the legal reasoning behind this decision, previously states could create districts that preserved the voting power of black voters by considering the racial factor. This was a clear requirement of the Voting Rights Act. The court is now saying the opposite. Drawing districts with race as a factor is itself unconstitutional. This decision does much more than reshape a state's map. This situation, while indicating a significant shift in constitutional understanding of equality, voting rights, and Congress's authority to enforce the Reconstruction Amendments, was based on a very simple principle before the decision. Section 2 of the Voting Rights Act was considered violated if an electoral system produced racially discriminatory results, even if discriminatory intent was not clearly proven. The effects of the Louisiana versus Callais decision will not be limited to a single state. If the enforceable protections of Section 2 are weakened in the redistricting processes, especially in areas where voting behaviors are sharply racially polarized, state legislatures may face much less federal obstruction when preparing maps that could diminish the political influence of minority voters. Post-decision domino effect. Which states took action? The process following the decision proceeded extremely quickly and coordinatedly. After the Supreme Court's serious blow to the Voting Rights Act, efforts to redraw congressional maps in southern states controlled by Republicans quickly began within 2 weeks of the Supreme Court striking a blow to Section 2. The chair of the Congressional Black Caucus, Representative Yvette Clarke, spoke at a press conference held on Capitol Hill on April 29, 2026. A spokesperson for the committee told ABC News that the group is working in coordination with organizations like the Elias Law Group and the Legal Defense Fund against these redistricting efforts. After redistricting efforts in southern states like Louisiana, South Carolina, and Tennessee, House Minority Leader Hakeem Jeffries promised a strong response and listed specific states without sharing specific details. About a third of the 62 members of the Congressional Black Caucus, 19, are at risk of losing their seats until the 2028 election cycle, as Republicans in control of state legislatures quickly redraw congressional maps less than 2 weeks after the Supreme Court struck a blow to Section 2. The mid-decade redistricting push is a continuation of an effort that began in 2025 and encouraged by President Donald Trump to increase the chances of the Republican Party maintaining control of the House in the November midterms.
This last sentence is extremely important. This redistricting process had already begun before the court ruling. The ruling accelerated an existing process and removed legal obstacles. Louisiana Republicans approved a new congressional map today that eliminates one of the state's 2 black majority districts and adds an additional Republican-leaning district in its place. Alabama front, the first concrete target. One of the most concrete results of this process emerged in Alabama. The Supreme Court paved the way on Monday evening for Alabama to eliminate at least one black majority congressional district before this year's midterm elections. This could potentially provide Republicans with an additional House seat in the closely divided chamber. This development shows how quickly the decision has turned into concrete results. Alabama had previously been forced by federal court rulings to create a second majority-minority district to preserve the voting power of black voters. This obligation was no longer in place, and its impact was not limited to a single congressional district in one state. The development was of a nature that could directly affect the overall power balance in Congress, and especially in a House of Representatives where the margins were very close. Even a single seat changing hands could determine which party would shape the agenda. Maryland front, Raskin's true position. The aspect of this story related to Raskin is not one of an exposing role as the headlines often imply. Raskin is a direct actor in this struggle, particularly as someone who argues that Democrats need to respond in their own states. Raskin made a comprehensive call for a redistricting vote in the Maryland Senate on Monday evening. With a letter addressed to the General Assembly Democrats, the 6-page argument landed in lawmakers' inboxes at 10:33 p.m. and targeted key points raised by Senate President Bill Ferguson in his opposition to mid-cycle redistricting. Raskin has long supported congressional measures aimed at transferring the redistricting process to independent commissions and openly opposed partisan gerrymandering practices. However, he stated that he has temporarily set aside this approach because he believes that Trump's MAGA movement operates under the assumption that Democrats will unilaterally adhere to traditional political norms. Raskin wrote, "When partisans made gerrymandering the official redistricting process in America, why should we unilaterally disarm?" Raskin wrote, "When partisans made gerrymandering the official redistricting process in America, why should we unilaterally disarm?" This is an extremely important nuance. Raskin has said in his own words that he is fundamentally against partisan gerrymandering, but in an environment where Republicans unilaterally wield this weapon, he argues that it is not right for Democrats to play by the rules and lose. Raskin said, "There will now be an overwhelming feeling that Maryland is joining Virginia and California." The state of Democratic redistricting efforts for 2028 is this. The House of Delegates passed a bill in February that would likely turn the state's 8-1 Democrat map into a 9-0. State Senate President Bill Ferguson has refused to bring the measure to a vote. So, in Maryland, what Raskin is arguing for is that his own party respond to this wave of redistricting in Republican states. This is not an exposing a secret conspiracy, but an open political strategic discussion.
The plan withdrawn, a war won. A significant part of this story shows that not every attempt to redraw borders has been successful. Republicans in the Georgia state legislature abandoned their plans to redraw the state's congressional and state legislative maps for the 2028 election cycle during a special session that began Wednesday. The decision to withdraw from redistricting came after widespread backlash and protests from Georgians and Democratic state lawmakers to prevent progress by attacking black political representation. Fair Fight Action CEO Lauren Groh-Wargo said in a statement, "Our voices and our votes have power, and when we show up and raise our voices, we feel that power. This fight is not over yet." Governor Kemp's failure to redraw the maps is a major win for black Georgians and Democrats, as the vast majority of black voters support Democrats. The pressure to redraw districts in Georgia posed a threat to eliminate a number of House and state legislative districts with black majorities or supermajorities. Republican Georgia House Speaker John Burns told Kemp in a letter that the legislature should wait to redraw the districts while court challenges to the current maps are ongoing. Burns also argued that the public should have more time to respond. This Georgia example is extremely important because it shows that these redistricting processes are not a one-way street. Public opposition can produce real results. Legal battle, return to the courts. The legal dimension of this crisis is not limited to votes in state legislatures. The Congressional Black Caucus also plans to fight through the courts. A spokesperson for the Congressional Black Caucus told ABC News that the group is working in coordination with organizations like the Elias Law Group and the Legal Defense Fund to oppose these redistricting efforts. This development indicated that one of the remaining legal options was being attempted after the weakening of Section 2's impact. That is, if federal law no longer provided sufficient protection, recourse to different constitutional bases, such as the Equal Protection Clause, could be considered. According to critics, this decision represented one of the greatest setbacks for a multiracial American democracy in the last generation, as it contradicted the purpose of the Voting Rights Act, the will of Congress, and the spirit of the Constitution. Table by the numbers, the meaning of 19/62. To grasp the scale of this crisis, the numerical framework needs to be clarified. About a third of the 62 members of the Congressional Black Caucus, 19, are at risk of losing their seats. 19 is not a bright number, but that's equal to a third of the board's membership. If these seats are indeed lost, it could represent the largest loss of black representation in Congress in decades. This number also has strategic importance. The mid-decade redistricting move is an effort encouraged by Trump to increase the chances of the Republican Party maintaining control of the House in the November midterms. So this is not just a racial representation issue, but a struggle that directly affects the overall political balance of Congress. Republicans see this redistricting as a critical tool to maintain their majority. Democrats' counter-strategy: let's not disarm. The philosophy expressed in Raskin's letter was a reflection of a larger strategic debate within the Democratic Party. Raskin wrote, "Why should we unilaterally disarm when they have made partisan gerrymandering the official redistricting process in America?" Raskin wrote, "When partisans made partisan gerrymandering the official redistricting process in America, why should we unilaterally disarm?" This assessment highlighted a genuine moral dilemma within Democratic politics. On one hand, there was the principled opposition to partisan gerrymandering practices, while on the other hand, the belief that not using this method while your opponent continues to do so would create a political disadvantage. Raskin also conveyed to his colleagues and close associates in the Maryland Senate that he had concerns that a possible redistricting effort could lead to new lawsuits. Indeed, the lawsuit filed against the initial redistricting plan in 2022 resulted in a state judge halting the Democrats' attempts to increase their seat count in the House of Representatives at the expense of the Republicans. This example showed that not only Republicans but also Democrats could face serious legal obstacles in their redistricting efforts, and that the struggle contained legal uncertainties for both sides. Conclusion: an open struggle, an uncertain future. The picture emerging from this story reflects a political battle that is much more complex and public than a secret plan. The Supreme Court's decision to nullify Section 2 triggered a rapid wave of redistricting in states like Louisiana, South Carolina, Tennessee, and Alabama. That wave put the seats of 19 black members of Congress at risk. Public protest in Georgia forced the withdrawal of this initiative. Democrats are discussing responding similarly in states like Maryland, California, and Virginia. Raskin openly advocates for this counter-strategy. He is not pursuing a secret plan, but rather is part of a public debate conducted through letters and press releases. The assessment from the Campaign Legal Center is as follows. Without this decision, states are free to draw discriminatory voting maps and enact discriminatory laws. This is a struggle that will reshape the representation structure of American democracy, and the outcome of this struggle will become clear in the November 2026 midterm elections, with which seats are retained or lost. If you want to follow this kind of analysis, subscribe and don't forget to turn on notifications. See you in the next update.